If you are thinking of dismissing an employee, that dismissal should fall within one of the 5 fair reasons of dismissal set out in employment legislation. These are conduct, capability, including performance and in some cases long-term sickness absence, redundancy, illegality and some other substantial reason. All employees are entitled to a fair hearing and, in the case of dismissal for conduct or capability, it is essential to follow the procedures set out in the ACAS Code of Conduct. The length of service of the employee will determine how you deal with their dismissal. Those employed before the 6th of April 2012 will need to have less than 1 year's continuous employment for you to be able to rely on the shortened or modified dismissal procedure. Those employees who've been employed on or after the 6th of April 2012 will need to have less than 2 years continuous employment, provided there is no discrimination issues involved. Employees with short service should be invited to a formal meeting in writing. At that meeting, the issues of concern should be discussed and the employee given the opportunity to put their points forward. Then there should be an adjournment and the issues that the employee has mentioned should be considered. Then the meeting should be reconvened and the employee told of the outcome, namely that they're dismissed. This should be followed up in writing. Employees that don't fit into the above category and have a longer length of service should be invited to a formal meeting in writing. The letter should include the issues that are going to be discussed, any evidence that is going to be relied on, including documentary evidence, the right for the employee to be accompanied to the meeting by a work colleague or trade union official, and it should give them a minimum of 24 hours notice of the meeting. The meeting should be held in private without any distractions. Any notes taken during the meeting should be signed by the employee before they leave. No decision or outcome should be given to the employee before full consideration has been given to all the evidence in front of the employer. Normally, the employer should tell the employee the outcome of the meeting after the meeting has been closed. This is normally in writing. On occasions, the employer has phoned the employee, but then followed it up in writing. Employees have a right to appeal against any decision made. If they do appeal, they should be invited to a meeting in writing. At the meeting, all the points of the appeal should be addressed separately, and a letter setting out the outcome should be sent to the employee, explaining that this is the end of the process unless the contract of employment states otherwise. It is important that all employees are fully aware of all the policies and procedures contained in the handbook, and you can prove that they know this. This will help with a safe dismissal and frame any allegations.